This is Dr. Mark Leiser, and I've decided to do a series of 5 lectures on why I think the digital omnibus is so important to protecting fundamental rights. This is the 5th and final of those 5 lectures. The first 4 lectures asked when the GDPR applies, when data becomes sensitive, and why uncertainty spreads into research, cookies, AI, and data spaces. This lecture asked the question underneath of all of them: who should write the rules that decide those boundaries? My answer is a division of labor. The EU legislator should settle the essential choices. The Commission should standardize technical detail where uniformity is needed. The EDPB should provide expert methods and consistent interpretation. When those roles blur, organizations cannot tell whether they are following law, prediction, or advice. Let's return to the coded neurological record that I provided in Lecture 2. The hospital can reconnect the code to a patient. The research consortium cannot. It has no key, no lawful access route, and no realistic matching data. Elena, the consortium's counsel, must decide whether the transfer can proceed. She finds the same basic idea in 3 possible forms. It might appear directly in the GDPR, it might be left to a Commission implementing act, or it might be explained in EDPB guidance. To a non-lawyer, those may look like 3 versions of the same sentence, but they're not the same kind of rule. Legislation sets binding rights and duties through the democratic process. An implementing act can create binding, reviewable detail within powers already granted by legislation. Guidance helps authorities and organizations interpret the law, but it does not itself rewrite the GDPR. Elena therefore needs to know not only what the words say, but who wrote them and what legal effect they carry. Think of the 3 forms as different jobs. Law draws the boundary. Implementation makes that boundary work in a consistent way. Guidance explains how an expert body understands it. That difference is important because it matters before anyone can actually act. If Parliament and the Council put the actor relevant test and its safeguards into the GDPR, Elena can design the transfer against an enacted rule. If the decisive elements are postponed to a Commission Act, she must wait to see how broad that delegated power becomes. If they remain only in guidance, she is predicting how supervisors may react later. The practical result is very different. A clear legal route supports investment in secure systems because responsible organizations can see the conditions in advance. A soft law route may still influence every audit and enforcement decision, but it offers weaker protection for reasonable reliance. In a regulatory system, the author and the legal vehicle are part of the substance. What must the legislature decide? 4 things are essential. First, whose ability to identify a person counts. Second, what an organization must show when it says identification is not reasonably likely. Third, how the law prevents evasion through processors, affiliates, outsourcing, or planned onward transfer. Fourth, what legal consequence follows when the evidence is good enough. These choices decide who falls inside the GDPR. They cannot be left as an empty space for another institution to fill. The law can still use flexible factors such as cost, time, available technology, access to extra information, and the purpose of the processing. Flexibility is not the same as uncertainty. The clean division is this: the legislature fixes the boundary and the safeguards. Technical institutions then keep the evidence and methods current. That gives Elena a rule before the data move, instead of requiring her to design around the strictest interpretation that somebody might adopt later. The Commission proposal deserves credit for recognizing that the existing test did not give a sufficiently clear operational answer. It proposed an actor-relative clarification and a power to adopt implementing rules. That moved the issue from informal interpretation towards legislation. The difficulty was the width of the proposing implementing power. Criteria that decide whether information falls outside the GDPR do more than standardize paperwork. They change the regulation's reach. If the basic law leaves the central test open, the Commission may end up making an essential policy choice through a technical procedure. The better answer is bounded implementation. The GDPR should state whose capabilities count, how circumvention is treated, and what follows from a properly evidenced assessment. A Commission Act can then standardize forms, testing protocols, technical evidence, and interoperable records. In Elena's case, the legislature answers whether the consortium can ever be treated differently from the hospital. The Commission can specify how she proves that the conditions are met. The Cyprus Compromise took the opposite approach. It deleted the Commission's Article 4 clarification and implementing power, and placed more weight on a new Article 29A and EDPB input. Cyprus did not secure a Council mandate, so that text never became the Council's position. More importantly, deleting the proposed rule did not restore a neutral legal world. The court has already said in EDPS versus SRB that identifiability depends on the actor and the realistic means available to that actor. The EDPB's 2026 anonymization guidance then accepted that the same data may be personal for one entity and anonymous for another. The debate therefore moved on. The issue is no longer whether context matters. It is how legislation should define the test, prevent abuse, and create a dependable route for evidence. Article 29A could carry part of that settlement, but only if it has a clear legal effect across the GDPR. A change of article number does not answer Elena's practical question. Once the law fixes the boundary, implementing rules can make the assessment consistent across the Union. They can require organizations to identify the actors, map direct and indirect access to extra information, test realistic routes to identification, record technical and legal barriers, and assess possible onward transfer. They can also define a common time horizon and a common way to record changes in technology. That matters because a dataset that is safely separated today may become easier to link tomorrow. Standardized evidence makes cross-border decisions easier to compare and easier for courts to review. But the method must stay inside the legal boundary. An implementing act should not decide that a processor automatically gets a different perspective, remove an anti-circumvention safeguard, or change the consequence of beating the test. Put simply, legislation answers the legal question. Implementation makes the answer repeatable. A clear legislative perimeter gives the EDPB an important and constructive role. The board can explain common attack models, identify useful technical tests, publish sector examples, and update methods as new data sources or computing techniques emerge. It can also coordinate codes of conduct and certification across national authorities. That is exactly where expert guidance adds value. The legislature cannot describe every future linkage technique. The EDPB can keep the practical toolkit current and help authorities apply the same concepts consistently. The limit is simple. Guidance should make the law usable. It should not move the boundary without legislation. Elena should be able to follow an improved method because the GDPR tells her what that method achieves. She should not have to treat guidance as binding when an auditor demands it, yet discover that it offers no dependable protection when a supervisor later changes direction. Expertise works best inside a settled legal frame. The missing bridge is assurance. The consortium should describe the exact environment it is asking the law to assess. Who receives the data? What other information can they access? What technical, contractual, and organizational barriers exist? What testing has been done? Where may the data travel, and when will the assessment be reviewed? If that dossier follows an approved method, and where appropriate receives independent certification, the law should give it a practical consequence, a rebuttable presumption that the recipient lacked means reasonably likely to identify people at that time. Rebuttable is the key word. That is not immunity. The presumption should fall away if facts were hidden, separation was artificial, identification was arranged through another party, the data escaped the assessed environment, or capabilities materially changed. That balance rewards real privacy engineering without rewarding clever paperwork. Elena gains a defensible basis for approval, while supervisors retain power to act when the evidence or the architecture does not match the claim. The consortium does not meet only one body of law. A health data project may involve data protection authorities, AI authorities, health data bodies, cybersecurity regulators, and in some settings, consumer or competition authorities. One authority's decision can change the work of the others. My report therefore proposes a legal duty to cooperate where mandates materially overlap. Authorities should give early notice, lawfully exchange necessary information, respond within a reasonable time, explain important disagreements, and coordinate remedies where cumulative effects matter. This does not force consensus, and it does not give one regulator a veto over another. Independent authorities may still disagree. The duty simply requires them to make the overlap visible and reasoned. For Alina, that reduces the chance that one public body approves an architecture while another later treats the same feature as unacceptable without addressing the first analysis. Accountability should apply to the institutions that create the compliance environment as well as to the organizations inside of it. Supervisors often have more than one lawful way to protect rights. Those choices can have very different effects on research, smaller organizations, cross-border systems, and investment. The report's innovation mandate is a way to make major, general supervisory choices more accountable. For an important guidance document or a consistency position, the authority would identify the legal problem, the risk, the evidence, the groups affected, and credible rights-preserving alternatives. It would explain proportionality, note cross-border effects, and set a date for review. The mandate has a firm limit. It operates only among lawful options. It cannot lower the rights floor, excuse a breach, or interfere with an individual complaint or sanction. It asks a public institution to show its reasoning while it makes a general choice with wide consequences. If a future EDPB method becomes more restrictive, Elena and the public should be able to see what changed in the evidence and why the new route is proportionate. That is administrative discipline, not deregulation. The report's legislative blueprint can be understood through three connected parts. First, stable triggers. Article 4 should state that identifiability depends on the relevant actor and realistic means, while keeping strong rules against artificial separation and planned access through others. A documented assurance route should turn good evidence into rebuttable reliance. Second, proportionate duties. Article 9 should protect deliberate and operational use of sensitive data strongly, while creating a narrow route for incidental or residual sensitive material in AI development. Article 22 should preserve protection against solely automated significant decisions and clarify what meaningful human involvement looks like. Research needs a clearer cross-border pathway with common safeguards. E-privacy should continue to protect the device, but use a low-risk, purpose-based list instead of demanding consent for every harmless technical function. Qualifying AI development needs a safeguarded legal route, not a blanket permission. Third, accountable institutions. Regulators should cooperate with their mandates overlap, and major supervisory choices should be supported by evidence, alternatives, and public reasons. These are not separate concessions to industry or rights groups. They form one design. Clear boundaries focus strong protection where capability and harm are real. Proportionate pathways make compliance usable. Institutional discipline makes the result more democratic and reviewable. The series has followed one problem from 5 angles. Lecture 1 showed that the definition of personal data acts as a hidden switch. Lecture 2 asked whose realistic ability to identify matters. Lecture 3 asked when sensitive meaning should trigger stronger protection. Lecture 4 showed how uncertainty multiplies across cookies, research, and data spaces. This lecture has asked who should settle those boundaries. Return one last time to Alina and the coded record. The hospital remains responsible because it can identify the patient. The consortium cannot create anonymity with labels or paper separation, but if it genuinely removes realistic capability, contains the data, documents the evidence, and accepts reassessment, the law should recognize that achievement. The institutional answer is equally clear. Co-legislators set the essential boundary and safeguards. The Commission standardizes bounded technical detail. The EDPB maintains expert methods and consistency. Authorities cooperate, and courts remain able to review the result. The digital omnibus is an opening, not a complete settlement. Europe should use it to make strong rights protection clearer, more workable, and more accountable. So, this brings us to the end of my lecture series, and I want to thank you for watching. If you have joined the series here, continue with the complete Restoring Legal Certainty playlist. You can also read the full DigiData report and subscribe for further lectures on European data and digital regulation.